Lordship's indulgence, Your Lordship. If I may be allowed to mention from part 2, there's item 3. If this can be taken up on Thursday. My learned colleague has some problems, but anyway, Thursday.
Let it come after a week,
So,
as paid for by Mr. A.R. Malhotra, learned counsel for the appellant, and not objected to by the other side. List this matter again after a week for hearing.
yeah, and similar prayer in item 6 also then.
Same order. Item 6. Yes.
My Lord, if I may seek your Lordship's indulgence in making mention of part 2, item number 8, my Lord.
Yes.
My Lord, leading counsel for this case is in bereavement. If this matter may be taken up after 1 week, my Lord.
For the appellant?
I'm for the
Oh, sorry,
respondent.
for the respondent.
Yes, my Lord.
Okay, learned counsel for the respondent number 1. Is said to be in bereavement and on a prayer made on his behalf and not objected to by the other side. Matter stands adjourned for
1 week, my Lord.
a week. Okay.
Obliged.
May I seek your Lordship indulgence on mentioning item number 4, part 2. My Lord, with the consent from the other party, if the matter may be taken up on next week,
You're for which party?
I'm for the appellant, my Lord.
What's your good name? Your name?
Lal mga isanga. On behalf of Mr. Johnny L. Towson.
Okay. And who's for the other side? Have you taken consent?
Yes, my Lord, I have taken their consent.
Mr. Van Lal Mga Isanga.
Lal mga isanga.
Mr. Lal Mga Isanga. Give your name in writing.
Okay.
Mr. Lal Mga Isanga, learned counsel for the appellant submits that Mr. Johnny L. Tochong, learned counsel for the appellant, has some personal difficulties to appear before the court today and prays that the matter may be adjourned for a week. To stop, he submits that he has taken the consent of the other side as well. Next para, in view of above, list this matter again after a week.
As obliged.
May it please your Lordship, on behalf of my senior, I kindly request that item number 9 of Part B hearing list, if this be fixed for this coming Thursday, my Lord. That is the 28th.
Not on Thursday. You may have it next week.
Okay, my Lord.
Okay. You are mentioning for the petitioner?
Yes, my Lord.
Okay. Mr. Jordan Romingthang, a learned counsel for the petitioner, is said to have some personal difficulty to appear before the court today. Stop on a prayer made on his behalf. The matter stands adjourned for a week.
May it please your Lordship, I'm appearing on behalf of the learned AG, and this matter was last listed on Friday, and notice has been served to the opposite party, your Lordship.
Yes.
Yes, my lord. As per the Supreme Court judgment, the continuation may be allowed, my lord. We have gone through the Supreme Court judgment.
Please write down. Heard Ms. Lalnun Louis, learned government advocate for the applicants, and Ms. Manlom Sangi.
Rosie Manlom Sangi, my lord.
Huh?
Rosie Manlom Sangi.
Ms. Rosie Manlom Sangi. Please give in writing, okay?
Yes, my
Is
lord.
it available in the cost list?
Yes, my lord.
Okay. Ms. Rosie Manlom Sangi, learned counsel for the sole respondent. By filing this writ petition, by filing this application, the applicants seek for condonation of 686 days delay in filing the connected regular first appeal. Stop. This court, right, order dated 1/10/2024, declined to condone the delay and dismissed the application. Stop. The applicants have, however, approached the Honorable Apex Court by filing what is the case number?
Before the Supreme Court, Your Lordship.
Yes. Okay, by filing civil appeal number 009869 of 2025, arising out of SLP bracket civil diary number 2247 of 2025. Stop. The Honorable Apex Court wide order dated 28/7/2025 condone the delay. Subject to the deposit of the entire amount of compensation before the registry of the court within 4 weeks. To stop, the Apex Court also permitted the respondent to withdraw 25% of the deposited amount, while directed the remaining balance amount to be kept in a high interest bearing FDR, capital FDR account of a nationalized bank. Next para, Ms. Lal Nunlui, learned government advocate, submits that pursuant to the order passed by the Apex Court, the amount as directed has been deposited. The entire amount of compensation as directed by the Apex Court has been deposited before the registry within the stipulated time. Next para, in view of above, the application for condonation of delay stands allowed in terms of the order of the Apex Court dated 28/7/2025. IA is disposed of. Then what about the main? When do we list it?
Your Lordship, if the matter may be listed after 3 weeks.
3 weeks.
Yes, Your Lordship.
In view of the order passed today in RFA number 12 of 2024, let the appeal be listed after 3 weeks as prayed for. You follow up regarding the withdrawal and all that.
Yes, my lord.
Okay?
Yes, my lord.
You submit an application and you can withdraw the amount.
And
Yes.
one submission, my lord, that I have just received the IA 64 of 2025, that is the stay or application for stay. And my lord, we have just received this IA this morning. So if we may be given time for disposing this IA.
Surely.
Yes,
You
my
file
lord.
an objection if you want to.
Yes, my lord.
Liberty is granted to the respondent to file objection to IA number 64 of 2024,
2024.
if so advised.
Much
Yes.
obliged, Your Lordship.
Obliged.
Item 7.
Yes.
Your Lordship, my senior is on legs, so if this matter be called for the last item.
Huh?
My senior is on legs, so if this matter be called for the last item.
Okay. You are aware about this case, isn't it? It
Yes.
came up last Friday, I think. And interim bail was granted by the trial court. So you could have approached the trial court for extension of the interim bail. Anyway, let her come, okay? Passed over, time being.
Item 8.
My lord, the counsel for the petitioner is on legs, so if this matter may be passed over for the time being.
Time being, okay?
Condition, item 1.
Mrs. Dinari,
Yes,
matters ready for
yes,
consideration.
yes.
We'll take it up after some time. Let us do the other matters.
Fine.
Hold the next
Item
item.
2.
Reply affidavit.
I won't be filing any reply.
Mr. A.R. Malhotra, learned counsel for the petitioner, submits that after perusing the counter affidavit carefully, the petitioner will not be filing any reply affidavit. To stop in view of above, list this matter for admission hearing after
Yeah,
a week,
in the coming week,
after a week,
next week.
in the next week.
Item 3.
May I please, Your Lordship, my Lord, pleadings are complete now. And if Your Lordship permits, it may be fixed on 3rd September, my Lord, for admission hearing.
Mr.
4th September, my Lord. Sorry.
Okay. Parties are represented by the respective councils and they submit that the pleadings are complete and the matter be listed for admission hearing on 4th of September, 2025. Stop in view of above, list this matter for admission hearing on 4th of September, 2025.
Obliged, my Lord. Obliged.
Item 4.
May it please Your Lordship. My Lord, this case is being listed for the first time, and notice can be issued. But we have, and the case is filed within the period of limitation. But I have submitted one IA for consideration at this stage, if possible, Your Lordship.
What is that?
Your Lordship,
Stay.
but stay, Your Lordship, stay of the
The
judgment.
notice will have to go at this stage.
At least till the next court date, Your Lordship. Because the reason being is that, Your Lordship, in my IA, I have an X1 communication that was issued to me by the Revenue Department for submitting my original LSCs for mutation in favor of the plaintiffs.
What is the matter regarding?
Yes, Your Lordship. The present appellant was the defendant number 3 in this particular, in the main declaratory suit. So what happened was that the respondents, the other 2 defendants, number 2 and 3, entered into a verbal agreement with the plaintiffs who are arrayed as respondent number 1 and 2 for starting some business. Now, since they were having shortage of funds, they approached the present appellant for loan. However, I did not agree to that. Instead, we executed a sale deed, two sale deeds, one with the plaintiff number 1 and one with the plaintiff number 2 in respect of 2 properties. And that sale deed was also duly registered. And unfortunately, ex parte proceedings was initiated against the present appellant. However, the point that we are stressing on in this particular appeal, Your Lordship, is that despite failure for submission of written statement, the burden of proof still lies on the plaintiff to prove their case. Now, the judgment in order was passed on 2nd of June 2025.
You were a party,
I was a party.
but it was decided ex parte.
We did not submit the written statement within the stipulated timeline.
So didn't you file any application for
We
consideration?
did. That was rejected.
By which order?
Yes.
Before the same court?
Before the same court, my lord.
Then after that, you did not
Did
take further
not-
steps?
No, no further steps were taken. In any event, Your Lordship, the judgment in order was allowed on two grounds. One is that on the ground of fraud. Number two is that the consideration price for the sale was not handed over to the landowners, that is to the vendor. That was the conclusion of the trial court. However, Your Lordship, the recorded evidence says otherwise. It is on record that there was no fraud committed by the present appellant. In fact, the plaintiffs themselves affixed their signature. It is also on record that the amount of consideration was received by the defendant number 1, present respondent number 3, due to the fact that the plaintiff had identified him as his youngest brother. All those facts are there on record. Despite of that, Your Lordship, the judgment in order was passed. So everything, the conclusive portion is all against, is quite contrary to the recorded evidence. So the point that we will be stressing on this particular appeal is that the burden of proof was not discharged by the plaintiffs.
Now, who have been examined as witnesses? How many?
The plaintiffs number 1 and 2 plus one brother. Now the witness to the sale deeds were also not produced. And sale deed, as I had mentioned earlier, Your Lordship, which is at page 40, Your Lordship. It's a duly registered document, both of them. 40. Page 43 is the registration certificate with the concerned department. And the two witnesses to this sale deed, they were never produced by the plaintiffs.
How many LSCs are mutated in your name?
2 LSCs, Your Lordship. One belonging to the plaintiff number 1 and one belonging to the plaintiff number 2. And the plaintiffs are brothers and sisters, and the properties are adjacent to one another.
Why was it mutated in your name? Some loan was taken?
They approached me for availing loan. I said nothing doing. I don't want to enter into this business. Either you can sell me your property or nothing doing. So that's why we entered into to this sale deed. They have not denied executing this sale deed. In fact, this is a duly registered document that was not considered by the learned trial court at all. And if it is the contention of the plaintiffs that this was obtained by fraud, at least the least they could have done is produce these 2 witnesses to the sale deeds.
You have bought the 2 properties?
2 properties.
For certain remuneration?
Yes, Your Lordship.
So what is their case, the plaintiff's case?
Their case is that was obtained by fraud. Now, their case is that it is basically between the plaintiffs and the defendant number 2 and 3. The 4 of them had entered into an agreement to start one Toyota showroom business, for which I was approached for funding. And I said, I am not into the business of loaning any money. Either you sell me your property or nothing doing. So they sold me their property.
Who are this defendant number 1 and 2?
The defendant number 1 is the present appellant.
1 is the appellant? No.
Sorry, 3 is the appellant,
3 is
1
the
and
appellant.
2, sorry, I apologize. 1 and 2 are the persons who had approached the plaintiffs for starting a business, a Toyota showroom business.
Okay.
So since they did not have the available funds, all of them combined approached me. I handed over the money to them, and in return, they sold me their property. Now, The plaintiff's allegation is that this 1 and 2 never handed over the money to them, so there was no sale according to them. So they were defrauded by this defendant number 1 and 2. But it is clearly in evidence that in the entire, even if there was fraud played, in the entire proceedings, number 3 was never a party to it. That is on record. So basically, dispute between the plaintiffs and the defendant number 1 and 2, I'm dragged in the middle.
Now, pursuant to the order of judgment, what is the steps taken?
I believe they've approached the revenue, and in my IA, at page number 9, I have been sent one communication dated 13th August 2025. English translation is at page 10. So basically, in light of the judgment and order in this particular case, I have been directed to submit my original LSCs.
In the IA?
In the IA, page 9, Annexure 1. This was recently communicated to me.
Okay, status quo to the next date then.
My lord.
Please write, heard Mr. Lal Fakoma, learned counsel for the appellant, who submits that by filing this appeal under section 96, read with order 41 CPC, and also read with section 17 of the Mizoram Civil Codes Act 2005. The appellant has challenged the judgment and decree dated 2/6/2025 passed by the Court of Civil Judge, Senior Division, Roman 3, Aizawl, in declaratory suit number 34 of 2017. The learned counsel submits that by filing the declaratory suit, the respondent numbers
1 and 2 are the
1 and
plaintiffs.
2 had sought for declaration of the mutation of LSC number 1032/01/682 of 2010 and LSC number 103302/01/683 of 2010 in the name of the appellant to be null and void. Stop. Similarly, the respondent number 1 and 2 sought for declaration of the deed of sale dated 24/11/2014 between the appellant and the respondent number 1 and its registration to be null and void. Stop. The learned counsel submits that the impugned judgment in order is contrary to the evidence on record, and that the respondent number 1 and 2 had failed to discharge the burden of proving the fact that the mutation in the name of the appellant has been obtained by fraud. To stop, he also submits that the deed of sale was not at all considered by the learned trial court in passing the impugned judgment. Stop. As such, the judgment and order dated 2/6/2025 should be set aside. Next para, in view of above, issue notice. Returnable by 3 weeks. Stop. Appellant to take steps for service of notice upon the. Who are the respondents?
Private.
All private.
The pro forma is district registrar, but Office of the AG had instructed us to take steps instead.
Upon the steps upon the respondents by registered post with ADD within 3 days. Next para, having regard to the above projection made by the appellant, it is hereby directed that till the next returnable date, parties shall maintain status quo as on today. List the matter again after 3 weeks.
Deeply obliged.
IA will dispose it of.
My lord.
In view of the order passed in the IA, in the main appeal, the IA stands disposed of.
Deeply obliged, Lordship.
Item 5.
May it please your lordship, I am here for the petitioners, and as per the direction of this honorable court dated 23rd/6/2025, we had taken steps upon the respondents number 5 and 6, but my lord, the AD card has not yet returned.
When was it taken?
23rd/6/2025.
On 5 and 6.
5 and 6, my lord.
Okay. What do you say? You are
Your
paying
Lordship,
for.
I'm representing the state respondent number 2 and 3, and I'm seeking 3 weeks' time to file the affidavit.
Then
Lordship, I'm appearing on behalf of respondent number 1 and 4.
you also want some time.
Yes, my lord.
For the petitioners and submits that steps was taken for service of notice upon the respondent numbers 5 and 6. On 25/6/2025.
My lord, 23rd. Steps were taken on 23rd/6, my lord.
But the office note says 25.
Oh, okay.
Show me the correspondence file, Court Master. From where are you saying 23rd?
From our record, my lord. Maybe, my lord, we have recorded wrong. My apology, my lord.
Indeed, the order was passed on 23rd.
Yes,
but
my lord.
Steps was taken on 25th. It was received on 25th.
Yeah, okay, my lord. My apology.
Steps was taken on 25th, 25/6/2025, but neither ID card nor unserved notice has returned by. Next para, Ms. Vanesiami, learned government advocate, appearing for respondent number,
2 and 3.
numbers 2 and 3, and Ms. Baby Laldin Zwali, learned counsel appearing for respondent numbers 1 and 4. Pray for further 3 weeks' time to obtain instructions and to file counter affidavit. Prayers allowed. List this matter again after 3 weeks.
Obliged.
Stop the registry shall also track the postal consignment of the notice sent to respondent numbers
5 and 6. my lord.
5 and 6 and put up a note. Yes.
Orders, item 7.
Yes, Ms. Nalga, is okay.
Yes, my lord. This is bail application.
See, you have applied for bail before the trial court. Interim bail was granted. And why don't you ask for the extension of that bail, interim bail?
Yes, my lord, they did ask for bail on 18th. 18th was the court date.
Then,
And the learned trial judge said that if she is not present, then I will not be hearing the bail application. So that is why we filed urgent bail application here.
no, if she's not present means the
The
applicant.
The applicant, my lord, she's in Guwahati for medical checkup.
She's in Guwahati.
Yes, my lord.
But
That
this
is
in-
why she could not
But this
appear
interim
in the-
bail was only till 18th of, for 1 month, isn't it?
Yes, my lord.
That 1 month expired, 18/7.
Recently, she was in Aizawl, then she moved to Guwahati.
Any difficulty on her part to appear before the court?
Yes, my lord.
What
She has to, my lord, if I may take your lordship to this medical that we have written. She has some problem with her ovarian cyst at page 3, para number 3.
Ovarian is okay, but she cannot walk and appear before the court.
Yes, my lord. it
How is
seems-
that? Where did you state that? There's no statement anywhere like that.
We have not specifically mentioned that, however, that, my lord.
So it's better you appear before the court and apply for extension of the bail.
My lord, right now she is in Guwahati.
Hmm?
She's in Guwahati.
So let her come, otherwise she'll be arrested. What is the charge? 21C.
21C.
Ah.
Then,
So
my
if
lord, nothing was recovered from her, and the trial is going so slow. They were arrested in 2023.
No, maybe, but thing is that, see, rightly or wrongly, you have been given interim bail, perhaps on medical grounds. So it was your duty incumbent on your part to appear before the court and seek for extension, if you have some difficulty.
Yes, my lord, that is why the trial judge did not want to entertain. That's why we approached this honorable court.
And why should this court entertain your bail application then?
Because her case is very genuine. Also, my lord, the trial, even though the charge sheet, I could not specifically, my lord, in the next court date, I will give the exact date where the charge sheet was
You tell me in your bail application, show me one statement where you have stated that the applicant is not able to appear before the court because of our health. Where is that?
My lord, if I may be allowed to file additional affidavit?
No, no, no. You cannot burden the application like that. See, if you want bail, you should have appeared before that court. If there was difficulty that you cannot at all travel to the court, there should be a statement here specifically saying that you are in no condition. Currently, where are you? You are admitted in the hospital?
Yes, my lord.
Where? Where is your statement?
That
that
at
you
the
are
time
admitted?
of filing, my lord, she was in Aizawl and then she went to Guwahati.
You approach the trial court, we'll give you liberty. Okay? Ms. Lalka Isaki,
My
fine.
lord, then in that case, if I may withdraw the application.
Withdraw.
Yes, my lord.
I'll pass the order. I'll ask you to go to the court concerned. Same thing. Okay, as paid for by Ms. Lalka Isaki, learned counsel for the applicant. The application stands disposed of as withdrawn. Okay.
Obliged.
Ms. Vanesiami, learned additional public prosecutor, appears for the state. Yes.
Item 8.
My lord, the counsel for the petitioner is still on leg, so
He's still on legs.
if the matter may be listed tomorrow.
My lord, there's some urgency in this case. I can wait, we can wait. It's still, we have time. Because there's an execution case pending in the trial court and it is listed today.
Okay.
Item 1.
Item 1.
May it please Your Lordship, Your Lordship, petitioners hearing are the DRDA staff initially and subsequently absorbed in the government service on July 2, December 2021, as directed by this Honorable Court in the petition number 175/2016 by judgment and order dated 22/11/2017, that it was provided in the said order that they should be observed like their senior who were the petitioners in the petition number 72/2006, who were already observed as directed by this Honorable Court by judgment and order dated 22/7/2008, which implies that upon absorption their past service under DRDA were to be counted as qualifying service for the purpose of pension benefit, leave and pay, and also that their pay should be fixed in terms of the last pay drawn by them immediately before the absorption, and also to grant pay protection in terms of the last pay enjoyed by them immediately before the absorption and accordingly continued therefrom. However, the state respondent denied the same, and they were treated as new employees in all aspects, that although they have already enjoyed the benefit of 7 ROP under DRDA, the state respondent, while determining the pay during the RDA had presumptively fixed the same as if they were under 6 pay. Being aggrieved, they have preferred this instant appeal. And Your Lordship, kindly see judgment and order, previous judgment and order, that is in 62, page 62.
How many petitioners are there?
There are 84.
84.
That is in Annex 6, page 82. This is the judgment of the previous judgment.
Page 62 or 82?
82, Your Lordship. Before that, Your Lordship, I'll read out the previous case, the seniors' case, the direction of their seniors' cases.
Where is that?
That is in operative portion, is, Your Lordship, page 70.
What is the case number? 72?
Case number is,
72 of 2006?
yes, 72 of 2006. Kindly see page 74. This is, para 20, Your Lordship.
Yes.
Having considered all the matters in its entirety and for end of justice, the respondent authorities are directed to absorb the writ petitioners into various line departments as suggested by the Director, Rural Development Department, Mizoram Aizawl, and approved by the Government of Mizoram via letter dated 27/6/2003. This exercise shall be completed within a period of 6 months from today. With the direction above, this writ petition is disposed of, however, with no cause. So after that, Your Lordship, they were absorbed. That is in page 76, Annex 4. In persons of the judgment and order of the Guwahati High Court Aizawl Bench, and on the recommendation of Departmental Promotion Committee held on 12/8/2009, the Governor of Mizoram is pleased to absorb the service of 46 numbers of directly recruited staff under District Rural Development Agency Aizawl, Lunglei, and Saiha into the state government service under Rural Development Department with effect from 5/1/2009 against the posts converted from the various technical posts by this order such and such. The past service prior to absorption shall be counted for pensionary benefit, leave, and pay only. This is the way they have absorbed. And I have also enclosed one of the petition, how they have protect their pay. That is in page 81, Your Lordship.
You just read page 76, isn't it?
Yes.
Past services for the purpose of pension,
Pension,
leave and pay.
leave, and pay. Accordingly, beside all the things, they have also protected their pay. That is in 81. One of the petitioners here in the pension book is here. We have printed. That is in 81, page 81.
Pay is protected.
Yes, protected. The last pay fixed under Mizoram Revision Pay of Rules 2010 of Srimati Lalramoy LDC at such and such in the scale of pay with such and such 1/7/2006. So it's continued, pay fixed on 1/1/2006. So it can be seen that it's pay protected, the last pay, immediately before absorption.
Yes, that is as per the Annexure 4.
Annexure 5.
No, Annexure 4 says pay
Past
service.
Yes, past service.
Past service prior to absorption shall be counted for pension, benefit, leave, and pay only.
Yes,
So past service is counted for pay also.
yes.
Now, what benefit is given to you?
They are treated us as a direct recruit. The pay is not protected.
Okay. What do they say in the counter affidavit?
Counter affidavit, they said that they have made a scheme wherein we are going to treat as a direct recruitment.
Scheme.
Scheme. They have prepared the scheme.
Where is the scheme?
The scheme is in page 122. Kindly see point 11, that is in page 123, 122. Serial number 11. All employees observed under this scheme will be treated as new employees in all aspects.
This scheme came up after the judgment.
Yeah, the scheme came up after direction of the Honorable Court to observe like the seniors. And Your Lordship, the direction is very clear.
Have you challenged the scheme?
Yeah, I have.
You have challenged?
Yes.
Okay.
And beside the scheme, Your Lordship, before absorption, they followed the 7 pay or 7 pay. However, by the time when they prepare for the fixation of the pay, they accepted 6 pay again. So I'll come to the sequence, Your Lordship, if you permit me. Kindly see the direction of this Honorable Court. It starts from page number Annexure 682. And operative portion is page 115. No. 111. Para 10. Your Lordship got it?
Yes.
It may be mentioned here that in the case of similar situated persons, appropriate action have been taken by the state government as per the order of this court as mentioned above. Therefore, there is no reason why the same action should not be taken in the case of writ petitioners. Accordingly, the respondents are hereby directed to complete the process of observing the petitioners who are entitled to be observed in terms of what has been stated above within a period of 3 months.
In terms of what has been stated above, where is that?
In terms, it may be mentioned that here in the case of similarly situated appropriate action, I have cited the previous case in this case. May be seen from page 101. Paragraph 5. You have reproduced the previous judgment here. And from this para 9 also we can so it's already highlighted in the previous judgment and the way they have taken action and they have protected their pay as well as given the pensionary benefit. So in the same benefit we have asked for in this case, and it was directed. Therefore, there is no reason why the same action should not be taken in the case of the petitioners. This is the right direction, Your Lordship. Nine, okay.
Page 110.
Yes. Para 9. DRDA is a society registered under the Society Act for implementation of poverty alleviation programs taken by the central government from time to time. The society has been in existence since 1993, and it does not look like it would be done away with in the near future, keeping in view the county's long-drawn war against poverty, especially in the rural areas. Therefore, certainly the service of the petitioners will continue to be needed for implementation of poverty alleviation schemes of the central government. The fact that the petitioners have been allowed to continue in their respective posts shows that their service have continually been utilized and will continue to be used in future too. In fact, the state respondent have not stated in their affidavit that their services are no longer required or are not going to be required in the near future. Therefore, there is no gain in saying that they are contract employees and they can be removed anytime. In fact, ours is a welfare state and the government is of the people, by the people, and for the people. Therefore, to say that the employees, in whatever status they may be, are at the mercy of the state would be against the very indeed philosophy and principle on which our polity is founded. It is clear from the letters of the central government and guidelines of DRDA that the central government is willing to share the burden of pay and allowance of the DRDA staff at the ratio of 90-10 basis. From this, it is also clear that what the state government would or should do is absorb the DRDA staff in line department and place them on deputation in DRDA, where their pay and allowances at the ratio of 19-10 basis shall be shared by the central government and state government. It is an opportunity for the state government to give employment to the people of the state by contributing only 10% to their pay and allowances. Therefore, the state government should verify the dates of appointments of the petitioners and take appropriate action for absorption of those petitioners who were appointed during or before the year 2008. That is when the new guidelines was issued or notified. It may be mentioned here that in the case of similar situated persons, appropriate action have been taken by the state government as per the order of this court, as mentioned above. Therefore, there is no reason why the same action should not be taken in the case of writ petitioner. So, my understanding is that, Your Lordship, in accordance with the previous, the seniors' writ petition, direction of writ petition, the state has already taken action. So the same action should be done in the case of these petitioners.
Okay, now let us go to the earlier writ petition.
Earlier writ petition.
What was the any specific direction given?
It's only that page 75, it's come from the para 20, page 74.
This is basically the direction to absorb.
Yeah, into various departments, and it's already approved while filing this petition. It is written here, petitioners into various line of department as suggested by the Director Rural Department, Mizoram Aizawl, and approved by the government of Mizoram White Letter dated this exercise be completed within a period of 6 months.
So the direction was to absorb them only. It doesn't say that you give them all the protection and all that.
Particularly, it's not saying that.
Then what is this 27/6/2003? Already approved by the
Absorption, it seems. I'll check it.
Is it available here?
I think that should be in the judgment. (27/6). In the particular order, 27/6/2003.
Somehow I don't find it, 27/6/2003.
Yes.
Basically, what you're asking is for your pay protection.
Pay protection, as well as pensionary benefit.
Counting your past service for pension and benefit.
Yes,
That is not done.
that is not done. And they have made a scheme which was in the page Annex 10. We have agreed by this scheme, especially is point number 11. And the way the pay protection, saying that they have made a pay protection. However, Your Lordship, before absorption, we have already given 7 pay. However, after absorption, saying that you cannot accept the 7 pay and cancel the 7 pay already taken before absorption. However, they accepted 6 pay without any basis. And I want to highlight, Your Lordship, we have taken any pay followed by the state of government, state of Mizoram. Even when they have a 6 pay, we have followed the 6 pay. And after that, the 7 pay introduced, and we have again followed. However, after we are absorbed, they are saying that the previous permission for the 7 pay, which was cancelled after we are absorption, and saying that we cannot protect your 7 pay, we are going to protect 6 pay only. So that is there. I show you, Your Lordship, kindly see, Your Lordship, Annex 17 and 18. Annex 17 is revision of pay rules 2010. Here, in pursuance of a DP and AR, OM such and such, all contract employees under DRDA who are employed with pay scale are hereby allowed to enjoy the Mizoram revision of pay rules 2010, that is 6 pay, as amended from time to time with effect from 1/1/2006, as admissible to regular employees under the government of Mizoram, subject to the following terms and conditions and availability of fund under District Rural Development Agency. Likewise, Your Lordship, Annex 18. In pursuance of DP and AR, OM such and such, dated 25/3/2010, all contract employees under DRDA who are employed with pay scale are hereby allowed to enjoy the 7th Central Revision of Pay as modified and extended to the employees under the Government of Mizoram Rules 2018 as amended from time to time with effect from 1/1/2021 as admissible to regular employees under the Government of Mizoram, subject to the following terms and conditions and availability of fund under District Rural Development Agency, DRDA, administration concerned. And after that, Your Lordship, all the district was informed that the Kindly see Annexure 23. No, just, I mean, 169, page 169. And here they have informed all the project director to, one, all project directors, DRDA, Mizoram, to CEO, MSRLM, Rural Development Department, fixation of pay under the 7th Central Revision of Pay as modified and extended to the employees under the Government of Mizoram Rules 2018. With reference to the subject and cited above, I am directed to convey the administrative approval of the government for fixation of pay as the 7th Central Revision of Pay as modified and extended to the employees under the Government of Mizoram Rules 2018 in respect of DRDA employees pertaining to your district as per statement enclosed. So they have informed all the district to enjoy the 7th pay. And that is the case. And after that, the scheme.
So, 7th pay was extended to you all
Yes.
by this document which you just read.
It was extended, but they have cancelled.
By which order?
That is in page 184, Your Lordship. You got it, Your Lordship?
Yes.
In the interest of public interest, the office memorandum pertaining to the 7th Central Revision of Pay as modified and extended to the employees under the Government of Mizoram Rules 2018 for all contract employees under DRDA, Mizoram, issued by Rural Development Department via 8/3/2020 is hereby cancelled and will be treated as null and void. That is in 18 October 2021. Kindly note that, Your Lordship, we are absorbed between July to December 2021. So after absorption, after you are entering into the state service, while we are in the DRDA staff, we have taken the 7th pay, which was cancelled after absorption. And this particular order was not conveyed to the district as well as ISOL. We have RTI reply. They have not received any of them, this particular. We have doubted this particular letter because the letter by the Undersecretary, between the Undersecretary and the Chief Controller Accounts, and the way they have issued this letter is it's very doubtful, Your Lordship.
Which letter?
Kindly see from this letter.
Which one?
I'll come to that. From Kindly see from Annexure 22, 180. This letter is pay fixation in respect of Group A officers and DRDA upon absorption. In enclosing here with copy of letter received from Chief Controller, Account and Treasuries, Government Mizoram, I am directed to request you to furnish pay fixation of Group A officer under DRDA as per their actual pay as per 6 pay for further submission to the Chief Controller of Accounts and Treasury for fixation of pay of the said offices. And the Undersecretary wrote to the Chief Controller Accounts, that is in Annexure 23, page 181, fixation of pay in respect of Group A officers under DRDA upon absorption. With reference to your letter cited above, I am directed to state that as the required information is collected from all DRDS, Mizoram, all the officers have claimed that upon adoption of the 7th pay, their pays were fixed and payment of their monthly salaries were made accordingly and updated in their service books. As this is the case, their office have no record of pay as per 6 pay at the time of absorption. However, statement of pay as per 6 pay received by the DRDA Group A officers immediately before adoption as on such and such is furnished by DRDA, which is hereby forwarded for your information and necessary action. Here, Your Lordship, the existence of the cancellation of adoption of 7 pay is never mentioned. And again, the Chief Controller wrote a letter to the Undersecretary. Now it will come the existence of this letter, Annexure 24, page 182. Here, asking the Undersecretary, with reference to the subject and letter cited above, I have the honor to request you kindly to inform this office whether the department, Rural Department or the Government of Mizoram issued written order or notification that not allowed 7th pay for officers, staff under DRDA. If there is any order or notification, copy of the same may please be furnished. So when they're asking for the thing, the said letter was enclosed in the letter to the Chief Controller Accounts. The next, Annexure 25, Your Lordship, here, letter by the Undersecretary. With reference to your letter cited above, I'm directed to state that Rural Development does not issue written order or notification that do not allow 7th pay for office staff under DRDA. However, the department issued an OM that dated 8/3/2021 enclosed that allowed DRDA employees to enjoy pay under certain which was but cancelled later by the department. So it came up the existence of the said. However, in the previous communication, they never mentioned the existence of the cancellation of the said 7th pay, adoption of 7th pay. This impugned order is doubtful. And Your Lordship, in their affidavit, the cause of this letter, saying that the previous adoption of 7th pay was without the approval of Finance Department. This is their reply. And however, according to the scheme guidelines, it's not required. The finance approval is not required. because there's a executive committee and governing body. If the fund is enough for the adoption of any pay revision, they are the authority to fix the pay, not the finance department. So, ultimately, their pay was fixed and protected in accordance. The last pay was accepted as 6 pay and presumptive 6 pay. And they have made, it seems that it looks like they have protected the emolument. However, the total emolument was saying calculation plus basic pay, DA, HRA. I have made a chart also. As a fixation of pay. However, the judgment says that the action taken in the case of the previous petitioner should be made in the present case. So that is the one stand. The second stand is that the previous adoption of 7 pay was without the finance approval. That's why they have cancelled. But they cancel after absorption. Kindly note that, Your Lordship. This is their stand. And you have filed the reply affidavit, wherein you have stated that the guidelines does not provide, does not require the approval of finance. And that they saying that even though the finance approval is not required, the letter issued by the same person means secretary, DRDA, so it can be acceptable. They're just saying like that. So it seems that, Your Lordship, I have filed my affidavit, date 30/7/2025. I have a I'll come to the para 4 of the said additional affidavit. Which was filed in the 30/7/2025. Your Lordship got it? Para 4. That the deponent would like to state that the services were regulated by the DRDA guidelines, which was published from time to time, and the same was enclosed in the writ petition as Annexure 2. However, only the extract copy of the said guidelines of 2008 has been enclosed in the writ petition. Some relevant provision is necessary to place before this Honorable Court for proper adjudication of the issue. As such, the complete set of guidelines on DRDA administration is enclosed herewith for ready perusal. That para 4.1, 4.2, 4.3 of the guidelines laid down the manner in which staff of DRDA shall be recruited and their future avenue. That para 4.3 stipulated amongst other that the total emolument for the staff may not exceed the basic pay and other allowances which are permissible by the state government for that post. That para 5.3 provided that the administration of the DRDS shall be carried out by a governing body. The governing body will provide policy directions approve the annual plan, and also review and monitor the implementation of the plan, including the different programs. They shall give such direction to the DRDA as may be necessary from time to time, and the governing body will meet once in a quarter. Paragraph 5.4 provided the composition of the governing body. Paragraph 5.5 provided that all executive and financial powers of DRDA shall be exercised by the executive committee as per a scheme of delegation of financial and executive powers to be determined by each state UT government, and this committee will be fully accountable in all matters of DRDA to the governing body as well as the government. The executive committee of the DRDA shall be headed by the CEO, executive director, and shall consist of all the district level officers and any other officers deemed necessary for planning and implementation of anti-poverty program. The project director of DRDA will be the member secretary of the executive committee, and the executive committee will meet at least once in a month. And that from the perusal of the guidelines, DRDA, it is apparent that the service condition of DRDA employees was under the administration of governing body of DRDA and the executive committee of DRDA. In other words, they were under the direct control of state government in all respect. So, and again, Your Lordship, there's a model agreement form wherein, kindly see here, Annexure 2. Yes.
Proceed further.
Yes.
I think let this matter come up next week. We'll need some thorough deliberation.
Yes.
Okay.
It is. It's,
Finance department is not a party?
here the finance is,
There's only one affidavit filed by the rural development. Ms. Lalundu, you appear for the,
yes, finance also a party, Your Lordship.
finance is also a party?
Yes.
Okay.
Respondent number 4.
They have not filed a separate affidavit, isn't it?
No.
They have not filed a separate affidavit.
And Your Lordship, in this case also, even in the model agreement form, it is mentioned that they'll follow the pay revision, every pay revision.
We'll fix it next week.
Yes.
Which date do you want? Monday, Tuesday?
No, not fixed date. Let come for the hearing, Your Lordship.
Will issue rule?
Rule may be issued and it will come for the regular hearing.
Heard Ms. Dinari Tiazu, learned counsel for the petitioners, and Ms. Lalundu, learned government advocate, appearing for the respondents. Issue rule returnable by 2 weeks. Since parties are represented, no formal notice is required. List this matter for regular hearing. After 2 weeks.
2 weeks.
Orders, item 8.
We'll come back. I'll come back in 5 minutes and take up this matter.